confusion because of the confusion which we have.
Para 58 of Minerva. Para 58 of Minerva Mills says, Para 58 of Minerva Mills, which is at page 2079, says that by granting immunity on a challenge based on Article 14 and 19, on the ground that the directive principles are being subserved, they say every legislation virtually will be protected by that umbrella. So they strike it down on the ground of basic structure, saying that giving an immunity from 14 and 19 would violate the basic structure. That's the problem.
Allow me to clarify
Yes.
the confusion which is chart.
Functional utility of 14 and 19 goes. Then
Take the chart for a second.
Yes.
Take the chart. When it comes to the third chart,
The third column.
the third column, whichever being, this is marriage.
Right.
The principles specified in clause C or any of the part.
All right. Now just let's wait here for a second. The words, the principles specified in clause B or clause C of Article 39 is subsumed in the expression all or any of the principles laid down in part 4.
Substituted.
Subsumed. It is subsumed.
The word used is anyway, subsumed.
Substituted is a legislative device, but subsumed means the larger includes the smaller. So if the earlier words are subsumed in what is substituted, then when the entirety of what is substituted is struck down, that will not result in the revival of what is the original provision. That's the problem.
Only a minute.
And if you read this now in the context of para 58 of Minerva, they say that granting this immunity on the grounds of 14 and 19 itself violates the basic features of the Constitution. That's the problem.
Lord, kindly, Lord,
Good amount of Minerva over.
I wanted to,
See, NJSC, I'll tell you one thing. NJSC, they realize that there is a problem. Namely, that when you strike down, that's why the Solicitor General was arguing, your counterpart was arguing that, look, if you strike down the NJSC amendment, that will not result in revival. That's why what did the court throw in the exercise of its 142 power? They said, one second.
not 142, the court interprets. Court interprets.
What did the court say? The court said that this will lead to a constitutional breakdown. We are not in a situation of constitutional breakdown. Why? Because if 31C is no longer there, all that it means that any law has to meet the standard of 14 and 19. No law is invalidated ipso facto.
My lord, that would be a,
Law has to be tested, that's all.
Lord,
There is no constitutional breakdown.
that would be
Immunity is
distinction
lifted,
without a
that's all.
difference, my lord, only to.
Law is lifted.
I'm sure your lordships would not try to come out of NJSC finding on 142. It was a finding. It may be wrong finding.
All right, no, forget 142. But NJSC, in 2 paragraphs, they say that this will result in a constitutional breakdown. Justice Kerr says that they will, we were trying to see whether there will be a constitutional breakdown in a case like this. There wouldn't be, because no law then becomes invalid. It's just that the law has to be justified by the state. Being a reasonable legislator.
I wanted to read few more paragraphs, but if your lordships have, my lord, decided to my lord, go into it, I wanted not, my lord, your lordships to persuade not to, for good reasons. But if your lordships, my lord, have decided, I have nothing more, lordship.
We have to look at it because NJSC doesn't, the logic of NJSC.
Doesn't refer, it's not referred, my lord. Therefore, my lord, I think advisedly not referred. Should we, my lord, expand the scope? Lord, would your lordships read para 70?
Do is this.
Only a minute,
What
only a
we
minute.
do is this. We have heard you now on this. As we have told Mr. Andhyarujana, he has to argue the 31C point. Let's hear Mr. Andhyarujana.
That means our point is rejected, my lord. But before your lordship rejects our submission, 2085.
Not rejecting it. Hear Mr. Andhyarujana, we've heard you on that.
That amounts, well, and doesn't matter, it's entirely your lordship's jurisdiction.
Yesterday we prevented him from arguing it. Let us hear what he has to say, then we'll take a call.
Lord, 2085, my lord, would your lordships come?
At the end of it, we may still say that 31C, we did not go into it at all. We may still say it and say that, well, Vaman Rao says this, Minerva Mills says this, NJSC says this. Or if he persuades us to a contrary viewpoint, we may take a contrary view, but we'll have to hear him for that. Because
Lord,
yesterday
only
we
a
didn't
minute,
hear
my
him.
lord. My lord, before that, would your lordships come to para 75 of Minerva Mills? My lord?
Yes.
It's 2085. And keep, my lord, section 4 in mind. Your lordships have read section 4.
Since we are on 75, why don't we reach 58 and then go to 75?
58. It's the challenge.
Let's go to para 58.
Meaning of 58 will also apply.
Yes, ma'am. It's 2079. It is in this light that the validity of the amended Article 31C has been examined. Article 13(2) says that states shall not make any law which takes away or abridges the rights conferred by Part 3, and any law made in contravention of that clause shall be, to the extent of contravention, be void. Article 31C begins with a non-obstante clause by putting Article 13 out of harm's way. It provides for a certain consequences, notwithstanding anything contained in Article 13. If it that denudes Article 14 and 19 of their functional utility by providing that rights conferred by this article will be no barrier against passing laws for giving effect to the principles laid down in Part 4. On the reasonable interpretation, there can be no doubt by the amendment introduced by Section 4 of the 42nd Amendment, Article 14 and 19 stand abrogated, at least in regard to the categories of laws described in Article 31C. The startling consequence which the amendment has produced is that even if a law is in total defiance of mandate of Article 13, read with 14 and 19, its validity will not be open to question so long as its object is to secure a directive principle of state policy. We are disposed to accept the submission of the learned Solicitor General, considering the 2 charts of cases submitted by him, that it is possible to conceive of laws which will not attract Article 31C, since they may not bear direct and reasonable nexus with the provisions of Part 4. But then, in our opinion, is beside the point. A large majority of laws, the bulk of them, can at any rate be easily justified as having been passed for the purpose of giving effect to the policy of state towards securing some principle or other laid down in Part 4. In respect of such laws, which will cover an extensive gamut of relevant legislative activity, the protection of Article 14 and 19 will stand wholly withdrawn. It is then no answer to say, while determining whether the basic structure of the Constitution is altered, that at least some of the laws will fall outside the scope. Now 75. Lord, we may have a serious issue with 31C, but someone will have to lay a challenge, my lord, not on the ground that it doesn't revive. And that challenge, my lord, will have to be, my lord, met with by us. There is no challenge, my lord.
It is struck down. So nobody can challenge it.
My lord, it is upheld by 13 judges as, my lord, in Keshwanand Bharti.
Reason, you
On-
see paragraph 58, the reason why it is struck down is
It's not struck.
shutting out an argument under Article 14 and Article 19
Lord,
on the
substitute.
basis of fundamental rights to a law is against the basic structure.
My lord, substitution is struck down. Section 4 of the amending act is struck down. 31C is upheld by 13 judges.
Talking in 1980, what happened? Once section 4, the amendment is struck down, what remains? The previous provision and the subsequent provision are in pari materia. In fact, the expansive provision is struck down, the limited provision goes with it.
My lord, I won't be able to go beyond saying that it is,
The
The-
same thing in para 61, see para 61 also.
Lord, I leave it to you, Lord.
Para 61 also see, Articles 14 and 19 do not confer fanciful rights. They confer rights which are elementary for the proper and effective functioning of a democracy. Then they say, if Articles 14 and 19 are put out of operation in regard to the bulk of laws which the legislatures are empowered to pass, Article 32 will be drained of its lifeblood. Then they continue, then the power to take away the protection of Article 14 is the power to discriminate without a valid basis for classification. And then in the end, they say, the nature and quality of the amendment introduced by Section 4 of the 42nd Amendment is therefore such that it virtually tears away the heart of basic fundamental freedoms. This is what they say in these two paragraphs.
No, may I have 5 minutes?
Then 362
No, I wanted to read, my lord, kindly note, my lord, few paragraphs. I will not read it, my lord, now that your lordships, my lord, seems to be convinced, my lord, on this. But para 75, my lord, for my satisfaction, for whatever
75.
this, my lord. 75, my lord, at page 2085.
Yes.
62 is also.
Then, these then are our reasons for the order which we passed on May 9, 1980 to the following effect. As my lords were saying, my lord, the operative part was pronounced first.
It says May 9,
Pardon?
although it was passed in August 80, specifically says these are for reasons the order were passed on May 9. It will be read as if it was passed.
Statement
on May.
later.
Yeah, the reasons came later. my lord. Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of the Parliament and is void since it damages the basic or essential feature of the Constitution. Lord, please keep Section 4 on the side, my lord. Page 3966. Please keep it on the side. Volume 4. 3966. Volume 4. And what Minerva Mill does. my lord. Lord, I have that, my lord, 3966, volume 4. Your lordships have that, my lord?
Yes.
I may read, my lord, for the benefit of everyone, my lord. In Article 31C of the Constitution, for the words, brackets, letters, and figures within comma, the principles specified in Clause B or Clause C of Article 39, the words and figure within inverted comma, all or any of the principles laid down in part 4, comma over, shall be substituted. Correct, my lord? So now they say that every entire chapter protects any challenge. Now the court, my lord, in the para 75 says in Minerva Mills, Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of the Parliament and is void since it damages the basic or essential feature of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or 19 of the Constitution if the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4. The substituted part, Section 55 of the amendment is beyond the amending power with which we are not concerned. So what is set aside is 4. And thereafter, my Lord Vaman Rao deals with this and says that the position prevailing before 42nd Amendment Act in 31C stands restored.
They don't say that in Vaman Rao. They don't say that there is a revival. Vaman Rao doesn't use the expression revival or restoration at all. Very careful. We saw Vaman Rao. We'll give you.
My Lord, would your lordships come to volume 2B, page 8? Volume 2B, page 8. Your lordships gets one?
Yes.
My Lord Justice, this is Vaman Rao. After Minerva Mills, after noting Minerva Mills, after noting that this bracketed portion is set aside or declared unconstitutional, holds this. Article 31C of the Constitution, as it stood prior to its amendment by Section 4 of the Constitution 42nd Amendment Act, which I read, is valid to the extent to which its constitutionality was upheld in Keshwanand Bharati. Article 31C, as it stood prior to the Constitution 42nd Amendment Act, does not damage any of the basic or essential features of the Constitution or its basic structure.
But this is prior to the substitution. The issue of revival was never dealt with.
After the substitution, my lords. I may be, my contention may be wrong. Factually, I'm right.
Actually, it's not so, because it says that 31C, as it stood prior to its amendment in 1976, is valid to the extent to which its constitutionality was upheld in Keshwanand. So it only tells us what is the decision in Keshwanand, namely that 31C prior to Keshwanand and as upheld in Keshwanand is valid. That's all.
Further,
It does not deal with what is the effect of the substitution having been struck down.
would your
not
lordships
here at all.
my Lord, it deals with 42nd Amendment, my lords. 42nd Amendment.
We have to deal with it. Vaman Rao doesn't give us an answer. Vaman Rao doesn't give us an answer to the conundrum.
Probably we lots of
We have
look at
to-
it like this. This paragraph stands on the same footing as paragraph 413 of NJSC judgment. It stands on the same logic and the same footing. It doesn't have to expressly say so. The conclusion is well drawn from this. Otherwise, the theory of vacuum would probably equally apply to every situation when
There's no vacuum here. That's the problem which you face.
There's a vacuum in the law.
There
It's
could
not
be a
about
vacuum. Parliament wanted a protection.
There's no vacuum in the law.
No, the vacuum in the, yes,
The law doesn't become, there would be a vacuum if the law.
Lord, my Lord, can I put it a little candidly? Can I put it?
The law still can benefit from the presumption that a law made to give effect to a directive principle is presumed to be reasonable.
Lord, can I put it a little candid? Can I put it a little candidly? 31C, as we read it, we find it difficult to accept the proposition that it is not even, it is immune from challenge. But Lord, it will have to be challenged in an appropriate proceedings. This may not be a proper procedure to declare 31C as non-existent.
The immunity, so they're entitled to say that the immunity doesn't apply. There's no question of challenging it.
There's no need to.
Once you set up the immunity,
But,
you can argue that the immunity does not
I will
apply.
still urge this, your lordship say that the vacuum principle is squarely upheld because what remains after 31C, second part gone, the first part gone,
Lord,
nothing
Lord,
remains.
it's
Therefore, there is a
difficult, my
vacuum.
Lord, to accept immunity,
There's a complete
but
vacuum.
not by not revival doctrine.
Deprivation of an immunity as a matter of constitutional concept is not a vacuum. Because the law is still presumed to be valid, the presumption of constitutionality.
IR
attached
Folio takes care of that.
It is
Folio takes
susceptible
care
to
of it.
challenge, that's all. It's only that it has to be justified.
If 31C had a
Lord,
legitimate place in the
Lord, may I-
constitution, it had a legitimate place in the constitution,
All right, I
minus
think what
42nd
you-
amendment, it would have had.
You've got your point. You've got your point. I mean, this is not a matter which is free from difficulty. Mr. Dwivedi, would you like to add? And then we'll call upon Mr. Andheri.
Yes, Lord.
My Lord, only, my Lord, before that,
The position prior to
Only one.
What we'll do is, we'll hear Mr. Andhyarujana, because we have not heard him. We'll have to put our doubts now to him as well.
Just
Lord,
just
two
3 minutes,
paragraphs,
I will
my
not
lord, can
argue.
I complete? Of
Two
NJSC.
Oh, sure.
And my lord, please avoid, my lord, for the time being, don't keep, my lord, that constitutional breakdown in mind. But it's not necessary. My proposition is that it is only when constitutional background is the result that revival does not take place, and in other provisions it takes place. Either it takes place or it does not take place. That's, my lord, that's respectful submission.
If we go by your theory of revival.
Para 5. my lord.
Article,
Wait, what?
if you go by the theory of revival, if Article 31C is now struck down, what revives is the position prior to Article 31C. That means the immunity goes.
Lord, if the honorable court believes it is struck down, Lord, I have nothing to say, but it is not. I don't think the other side says it is struck down. It is upheld in 13 judge judgment. It's not struck down. The amendment of 42nd amendment is struck down. But I leave it at that. Lord, I can't.
Which other paras, Mr.
Lord, 4106, volume 5.
106.
Para 989. No, this is a concurring view of Justice Joseph. Justice Kurian Joseph. Your Lordship gets, my lord? One word on the consequence. Though elaborate arguments have been addressed that even if the constitutional amendment is struck down, the collegium. I'm sorry, my lord, Justice Padiwala gets, my lord? One word on the consequence. Though elaborate arguments have been addressed that even if the constitutional amendment is struck down, the collegium does not resurrect, according to me, does not appeal even to common sense. The 99th amendment sought to substitute a few provisions of the constitution and insert a few new provisions. Identical situation to 42nd amendment. Once the process of substitution and insertion by way of a constitutional amendment is itself held to be bad and impermissible, the pre-amended provisions automatically resurface and revive. That alone can be the reasonably inferential conclusion. Legal parlance and common parlance may be different, but there cannot be any legal sense of an issue which does not appeal to common sense. That you, instead of X, you substitute with Y. The court says that Y is not a valid substitution. Then X would revive, rightly or wrongly, this is what it says. And the last, Lord, page 4156. Lord, the same judgment, Justice Goel's view, my lord, para 1110. 1110, my lord, page 4156. All the three honorable judges have, my lord, dealt with this issue. May I read? I'm sorry, my Lord Justice Padi. Only a minute, my Lord. My Lord Justice Padiwala. Placitum H at the foot.
The foot.
May I read, my Lord Justice? Look, this is the view of my Lord Justice Goel, my Lord. The contention that even if the amendment is held to be void, the pre-existing system cannot be restored has no logic. In exercise of power of judicial review, a provision can be declared void, in which case the legal position as it stands without such void provision can be held to prevail. It is not a situation when the position has not been made clear while deciding an issue. Power of this court to declare the effect of its order cannot be doubted, nor the decisions relied upon by the respondents show otherwise. I hold that on amendment being struck down, the pre-existing system stands revived. No, none of the honorable two judges do not mention about any breakdown. They, as a proposition of law, that you have substituted X by Y, Y is declared unconstitutional. Therefore, X revive. That's the word used. That's my. We'll elaborate, if needed.
Please bear in mind that the substitution happened by virtue of section 4. Section 4 enlarges. This is substitution by enlargement. This court holds that this is against the doctrine of basic structure and therefore void. It's very important. Whole of section 4 is void.
Just a second.
There are numerous judgments.
Substitution of original took place by
Section 4
enlargement.
by enlargement
This one,
or expansion.
by expansion. And second, you said section 4
Was declared null and void by exercising the doctrine of ultra vires on account of destruction of the basic feature of the Constitution. One, my lords, there are numerous judgments of this court without dissent that, including in the context of Article 13, that if a law is declared to be void, then it is void stillborn, void.
Any controversy on it, whether it is stillborn or it becomes void from the date of the declaration. That,
So,
just Matthew's judgment in Ambika.
so I would prefer to use void ab initio. So stillborn would mean, you know, it never operated, but what happens is that generally there is a time lag between the making of the constitutional amendment and the declaration of ultra vires by the court. So in the interregnum,
Acts may have been taken
that
place.
some things may have been done. So whenever a lordship declares ultra vires, a question arises, what should be the form of declaration?
You say what happened.
Whether a lordship will protect or not protect. But one thing is certain, that the law, unless made prospective, operates retrospectively from the date the law came into operation. So unless your lordship gives it prospectivity, partial prospectivity, retrospectivity
So it
with
argues that
protection,
the law was never enacted.
never enacted. So if section 4 is to be held to have never been enacted by virtue of this declaration in Minerva Mills, then the logical sequitur is that the section 31C, as upheld in Keshwanand Bharati, stands as part of the Constitution. There is no question of revival, resurrection. That's a misnomer, my lords. It stands. It was never substituted. Something which is void ab initio can never substitute. So sections 4 was dead or declared dead retrospectively. there is no prospectivity attached Lord, in the declaration in the Minerva Mills.
Yeah, now, we got the point. We'll hear Mr.
The other thing is, Lord, there's one more thing. Something absolutely inherent in the word substitution. Please have section 4 para 412.6 of the judgment which our lordships were reading. Page 3883. An earlier three-judge judgment has been approvingly referred to in the context of what is substitution.
This is what? What are you referring to?
Page 3883. Yes, NJSC judgment, which our lordships were considering. Central Provinces Manganese Ore Company, this is three-judge judgment, which is relied upon for revival direction.
In 2016, volume 5 assist.
Yes. Paragraph.
1977.
Huh? No, not there. NJSC is lordship. Reference was then made to Central Provinces Manganese Ore. We do not think that the word substitution necessarily or always connotes, I'm sorry, paragraph 412.6 at page 3883. But the chart is slightly defective. It suggests as if that portion is struck down. It's the entire section 4 which is struck down.
It is created by, it's a confusion created by the chart. No, it's our confusion.
By us.
Chart.
By us. So just read this, para 412.6. Kindly peruse this, 412.6. We do not think that the word substitution necessarily or always connotes two severable steps. That is to say, one of repeal and another of fresh enactment, even if it implies two steps. Indeed, the natural meaning of the word substitution is to indicate that the process cannot be split up into two pieces. Like this, if the process described as substitution fails, it is totally ineffective, so as to leave intact what was sought to be displaced. That seems to us to be the ordinary and natural meaning of the word shall be substituted. This part could not become effective without the assent of the Governor General. The state governor's assent was insufficient. It could not be inferred that what was intended was that in case the substitution failed or proved ineffective, some repeal not mentioned at all was brought about and remained effective so as to create what may be described as a vacuum in the state law. So maybe vacuum or not is not the question at all. Question is substitution is an amalgam. It repeals and replaces something. So it can't be that in part it is struck down, gone, but the repeal part remains. That's what this judgment said.
It was never there. It was never born because assent was not there.
No,
In this case, It came into effect, substitution was done, and then declaration.
No, the point is that once your lordship declares the substitution itself to be void. See, what are we reading? How do we read section 4 now? What are we reading? We are reading it as if section 4 have those struck down as void in Minerva, yet the substance of the amendment goes, the old doesn't revive, so it's a repeal. So the repealing effect is surviving. The repealing effect of section 4 is surviving. Therefore, notwithstanding the declaration that it is void. How can that happen, my lord? We are splitting up the declaration of the court in Minerva Mill. Part is void, part is surviving. Section 4 reads, this will be substituted. 4 is gone. So where is the substitution? So in a matter of substitution, it's an amalgam. The going out and the coming in are one intertwined act of the legislature. The whole goes. Unless the court splits it up, having found that it is severable, then of course the lordships can say that we are striking down this part of it, but we are not reviving. That the court never said. It declares the whole entirety of section 4 null and void. So it can't have a split effect. The third thing was, I'm not elaborating. There are numerous judgments which I can cite, but I'll do it when my turn comes. But the third and more important is, what is this doctrine of basic structure under 368? The doctrine is that if you damage the basic structure, then what you are doing, your act is beyond your competence under 368. So the amendment which brought about the enlargement is been held in Minerva Mill to be beyond the competence of the Parliament under 368. So what is beyond the competence, my lords, cannot have any effect at all. It can't be that it was beyond the competence, yet in part, in some little part, it is still surviving to have the repealing effect of what was upheld by 13 judges. And it has dangerous consequences, as the learned solicitor said, which your lordship, of course, will elaborate. What all can be amended, and then, my lords, every time this court will be, my lord, be troubled with this. How much of it is, my lord, reviving or not reviving? In my submission is quite contrary to Mr. Nariman's. He says, refers to that expression, stands part of the Constitution. That's what in Article 368 is, that once the bill is passed, it stands amended in terms of the bill. But he misses the expression which is earlier. Once it is passed and assented thereupon. Now, if it could not be passed, once it is void, it could not be passed, it could not be assented. So there is no question of the thereupon effect following. That is stands part. Merely because the ultra-virus declaration comes, my lord, after a decade, it doesn't mean that it was the last 10 years competence. That's a thing.
Can I just take 2 minutes? I'll just.
We'll now hear everybody later. Mr. Andarujana.
Lords, I'll just supplement 1 minute.
Get your full turn now. You get your full turn. There were 3 counsel on one self-evident proposition. Now, Mr. Andarujana.
Only 2 dates.
Let him argue.
2 dates.
In response, yes. Mr. Andarujana, please start now.
First of all, Lord, I want to express my gratitude to your lordships for taking up this point, Lord. But it is an important point, a point particularly important for the facts of this case. Lord, I fully understand the concerns expressed by my learned friends, Lord, the Solicitor General, the Attorney General, Mr. Dwivedi. But regretfully, my Lord, I disagree with almost every statement of law that they have made. Lord, Mr. Nariman's point, Lord, in my respectful submission, is a point which carries great force and a point which requires a determination by your lordship's bench. Now, my Lord, I have divided my arguments, my Lord, into 4 segments. But I'd just like your lordship broadly to know how I wish to address your lordships today. Lord, I will just frame the issue before your lordship precisely, because I think, Lord, it is important that we understand that we are dealing with the effect of a declaration of unconstitutionality on a substituted provision in the Constitution. And that is the precise issue. But I'll just frame it in a moment for your Lordship.
Just
And I will
effect of the declaration of a substitution, declaration of unconstitutionality.
Yes, Lord.
Just one second.
Yes, Lord.
Effect of the declaration of unconstitutionality on a substituted provision
In the Constitution. And my lord, and I think it is important, my lord, that we bear in mind the distinction of this issue from other legislative activities such as repeal and introducing the laws. My lord, it is an important distinction to be borne in mind in my respectful submission. My lord, I hope that I will persuade your lordship, so that is the case. My lord, so my lord, the first part, my lord, I wanted to address your lordship on, my lord, which will nail, my lord, to the mast, my lord, with some certainty, my lord, what exactly factually took place. My lord, so much will become evident from that, because I will show your lordship that for 20 years, in fact, for about 22 years, my lord, there was no Article 31C did not exist in the Constitution at all. It came in later. Lord, I'll also tell your lordship, Lord, in a nutshell, my lord, about the reasons for introduction of Article 31C. Well, there is no constitutional chaos which is going to result, as your lordship alluded to, for different reasons. But I also want to set out, my lord, how the Minerva Mills judgment came to be. And I want to point out to your lordship that actually the problem is a problem post Minerva Mills. So it is a problem post 1980. So not if we bear that in mind. But the issue that we have is a post 1980 issue. But that will all become evident, my lord, in my legislative history. But the third issue which I want to address your lordships on, so the first was to frame the issue correctly. But the second, my lord, was to deal with legislative history very swiftly, my lord. I won't take your lordship's time on that. And my lord, the third, my lord, I wanted to deal with the effect of Lord Minerva Mills, Vaman Rao, and the successor judgments. My lord, there are in particular two, my lord, Sanjeev Coke, and the other one is the Bhim Singh Ji judgment. My lord, and also, my lord, there's another judgment called Basanti, my lord, which actually dealt with the 31C challenge to MADA itself, where also, my lord, 31C was noticed and the learned judges proceeded on the basis that in fact it was valid. So, Lord, I'm going to show your lordships all of those. Lord, I hope to immediately and swiftly show your lordship that Minerva Mills clearly proceeded on a concession which was made by Mr. Palkiwala, Lord, who was arguing the case. But the issue, in fact, never arose in Vaman Rao, which will also become evident from the dates in my legislative history. It could not have arisen because the question of striking down was not before the court in Vaman Rao at all, for that simple reason. But, Lord, I hope to elaborate on that. Now, Lord, I also, Lord, in the next segment of my arguments, Lord, want to deal with the NJSC judgment because, Lord, it is, I did find it, Lord, curious that my learned friends relied upon it because that judgment, Lord, was a judgment I wanted to rely upon. Lord, it entirely, in my respectful submission, Lord, supports my arguments, as I will show you, Lordship. Lord, and it distinguishes, of course, that amendment as saying that that amendment was not a substitution. Well, that really, my lord, is the short point with regard to the NJSC judgment. I hope to make that good. When it otherwise, my lord, fully accepts, my lord, the submission that in fact there is no doctrine of automatic revival. My lord, the last part of my address, my lord, is on the consequential aspects in the event that I am to succeed. My lord, there will be no, my lord, constitutional chaos. There will be no crisis, as I will show your lordship. And to your lordship's very pointed question about whether this is purely a technical point, in the sense that Parliament can always step in and take the necessary steps to redress it. Lord, I'll make a few comments on that. So, Lord, that is how I propose to go about this. My lord, my time estimate, my lord, is approximately 2 to 2.5 hours, if your lordship will permit me that. Lord, so, Lord, I will straight away start. My lord, by, if your lordships don't mind, my lord, I have prepared a note on this. My lord, I have prepared a note on this. My lord, the note is actually what I gave your lordship yesterday, and the same note from which I argued the Coelho point. My lord, today, my lord, I will be relying on serial numbers 1 and 3. My lord, the note has an index in front, if your lordship will see it. My lord, it has 3 items, but Roman 1 is legislative history, and Roman 3 is whether 31C is a dead letter. But, my lord, before I go to the note, my lord, I wanted to, my lord, give your lordship, my lord, a brief overview of the legislative history. My lord, it is not even necessary to read this note. My lord, I think I can effectively bring it out in a few minutes before your lordships. Or do your lordships have the note, just so that?
It's one. Where is your note?
My lord, it's 1B in the Google Drive, 1B.
Volume 1B.
Lords. The name is note tendered by Mr. Zalti and the original senior advocate.
I've got a lot of.
Legislative history of Article 31C.
Yes, no, my lord, it says, yes, legislative history of 31C of the Constitution is the first item, relevant to the present case. It's not a general history, my lord, relevant to the present. But if all of your lordships have it?
Just 1 second.
Yes, please.
I have one. This garbled version. Let me see if.
Please.
Start. Okay. Yes.
Lord, so, Lord, it is a longish note. So, Lord, I'll just summarize it first to your lordships. Lord. Lord, just your lordships will kindly mark one date, my lord. That is item 5 of my list of dates. Lord, that is 20th April 1972. And that is the date of insertion of Article 31C.
What are you reading? Which page?
Lord, it's page 6, PDF page 6.
Yes.
So, my lord, your lordship will just note that date. Now, my lord, I first wanted to address your lordship on some constitutional events prior to that. My lord, on 18 June 1951, we have the First Amendment. My lord, just orally, my lord, just a few minutes. My lord, the First Amendment, my lord, introduces Article 31A and Article 31B. My lord, the speeches piloting it through Parliament, my lord, which are given by Pandit Nehru, my lord, all indicate that it is really for the purpose of agrarian reform. Which was one of the important platforms for a lot of the Congress Party back then. But it is immediately challenged, Lord, in Sankari Prasad's case in 1951. Lord, Sankari Prasad's case, the challenge is whether 31A and the amending law of the Constitution amounts to law under Article 30. Lord, and the question is therefore, if constitutional law is law as understood under Article 13, Lord, if it is law as understood under Article 13, then the effect of that on Part 3 was to be considered. Lord, Sankari Prasad rejects that challenge. But several years later, in Sajan Singh's case in 1965, Lord, Sankari Prasad's view is upheld. Lord, in 1967, Lord, we have Golak Nath's case. As your lordships know, Lord, Golak Nath resulted in a 6-5 majority. And the effect of the 6-5 majority was to hold that section 368 is not the source of the amending power of Parliament. It is a general power that the Parliament has. And that Article 13A, law, constitutional law, is the law which, my apologies, Lord, that the law under Article 13A is constitutional law, namely the law which is used to amend the Constitution from time to time. Now, Lord, as a result of Golak Nath's judgment, your Lordship knows that Golak Nath then set out the principle of prospective overruling, which was till then, Lord, actually a concept which was alien to our jurisprudence. But, my Lord, as a result of this, Lord, there was a severe limitation, Lord, which was then placed on the constituent power of Parliament. But Parliament reacted, Lord, by introducing 2 amendments. Lord, the first amendment was on 5th November 1971, which was the 24th Amendment. Lord, they made certain amendments to Article 13, added Article 13.4. Lord, and they made significant amendments then to Article 361 and to the marginal note, effectively making it clear that Parliament had an unlimited power to amend.
Yeah.
Lord, on 20th April 72, then they introduced the 25th Amendment, that is Article 31C. Now, Lord, my point, Lord, my limited point, but thus far is this. Lord, that from inception, Lord, Article 31C did not exist. Article 31C came about as a parliamentary reaction to the judgment of the Supreme Court in Golak Nath's case. So, my Lord, it was to some extent, my Lord, in the Parliament, the tension between Parliament and the court manifested itself in the 25th Amendment, namely on 20th April 1972. So, my Lord, from the date of inception to the Constitution till 72, my Lord, chaos did not reign. My Lord, there was no anarchy in the country. My Lord, the constitutional provisions remained as they were. And my Lord, if I am right, my Lord, we will revert to that position, my Lord, prior to 1972. Now, my Lord, Keshav Nanda's judgment, my Lord, comes immediately, shortly thereafter, because, my Lord, in fact, my Lord, the 25th Amendment is immediately challenged, as your Lordship knows, one of the aspects which is challenged in Keshav Nanda's judgment. And, my Lord, we have the judgment then on 20th April 1973. My Lord, Keshav Nanda's judgment notices the basic structure, my Lord, which is then further commented upon in Indira Gandhi's case. Now, my Lord, we have the 42nd Amendment, which comes on 18th December 1976. Now, my Lord, the 42nd Amendment, my Lord, has the effect of expanding Article 31C. And your Lordship will find this, my Lord, in my list of dates, if your Lordship will kindly look at PDF page 12. But I'll just read to your Lordship, so your Lordship has in an orderly manner, Lord, what the amendment did. But your Lordships, all of your Lordships have that. But it's item 8, page 12.
PDF page 12.
Yes, Lord. PDF page 12. Item 8.
And there we have that section 4, which we read from Minerva Mills.
Yes. But I quickly just breeze through it to give your Lordship a comprehensive view. The Constitution 42nd Amendment Act, inter alia amending Article 31C, received the assent of the President of India. The amendments were as follows. Insertion of new subheading after Article 31. After Article 31 of the Constitution, the following subheading shall be inserted, saving of certain laws. 4. The amendment of Article 31C. In Article 31C of the Constitution, for the words, brackets, letters, and figures, the principles specified in Clause B or Clause C of Article 39, the words and figures, all or any of the principles laid down in Part 4 shall be substituted. Lord, there was also then an amendment which was made to 368, Lord, which is not really relevant, but for the sake of completeness, Lord, I have said it out to your Lordship. Now, Lord, if your Lordship will then go down to item 9, my Lord, how did it stand as a result of the amendment? I've set it out there. Lord, the amended, well, this is at PDF page 13. The amended Article 31C read as under, saving of laws giving effect to certain directive principles, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any rights conferred by Article 14, 19, or 31 no law containing a declaration that it is for giving effect, my lord, so on and so forth. My lord, as we know, my lord, part of it, my lord, was then subsequently set aside. Now, my lord, if your lordship will just go to item 10 and kindly note the date also. My lord, in 1977, the writ petitions were filed under Article 32 in the Honorable Supreme Court in Minerva Mills and Union of India, inter alia challenging the constitutional validity of Section 4 and Section 5 of the Constitution 42nd Amendment Act 1976. The writ petitions under Article 32 filed in the Honorable Supreme Court in Vaman Rao versus Union of India, inter alia challenging the constitutional validities of 31A, 31B, and unamended Article 31C. So, my lord, these two matters, my lord, have historically always moved in step and moved together. Now, my lord, a very interesting development takes place immediately thereafter, which I want to bring to your lordship's notice, my lord. On 15th May 1978, the Constitution 45th Amendment Bill, so my lord, this is the bill of 1978, which is Bill 88 of 78, to further amend the Constitution of India was introduced in the Lok Sabha. Clause 8 of the bill read as follows. So, my lord, this was an attempt by Parliament. My lord, the government had now changed, and it was an attempt by Parliament to actually once again narrow the effect of Article 31C, as your lordship will see. So, my lord, the amendment, my lord, and my lord, 8 of the amendment read thus. My lord,
They wanted to restore the position as it was prior to the 42nd Amendment.
Exactly. My lord, they wanted to restore the position as it was prior. My lord, and as I will show your lordship, my lord, from this, actually, my lord, the bill, my lord, of course, my lord, passed as an act, but without this portion being passed by the Rajya Sabha. So, my lord, if your lordship will just permit me to read this through, my lord, that will become evident to your lordship. My lord, for the words, figures, all or any of the principles laid down in Part 4, the words, brackets, letters, and figures, the principles laid down in Clause B or Clause C of Article 39 should be substituted. So, that is what they wanted to bring back. For the words and figures 14, 19, and 31, the words and figures Article 14 and 19 shall be substituted. Now, the second part was successful. Lord, 31 stood deleted. The first part was not. The words "and no law containing a declaration that is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy shall be omitted." Now, my lord, that was the portion. But that was the portion which had been dealt with by Keshav Nanda.
Proposed bill which never passed the Rajya Sabha. So 31, 19(1)(f) was deleted, 31 was deleted, but this remained as it is.
Exactly, this remained as it is. And not of note, my lord, is the deletion also. My lord, when and why, my lord, it. Sorry.
Omission of what?
Now, my lord, if I may just read the notes.
Yes.
Sorry, if I just read the note to that, my lord. The notes on clause to clause 8 read as follows. The amendment proposed in subclause A or this clause is for confining the protection afforded to Article 31C only to the laws giving effect to the policy of state towards securing the directive principles specified in clauses B and C of Article 39. This would have the effect of restoring the article to the form in which it stood before the amendment made to the article by the Constitution 42nd Amendment Act 1976 came into force. The amendment proposed in subclause B is consequential to the omission of Article 31 above. The amendment proposed in subclause C is for omitting the portion related to the declaration contained in Article 31C, which was struck down by the Supreme Court in Keshav Nanda Bharati. Now, Lord, that is a point which I want to develop a little later on. What is the effect of a declaration of unconstitutionality on a constitutional provision? Lord, it is now, I respectfully submit, an accepted position that it does not get excised from the statute book. It remains in the statute book, and it actually has to be removed by Parliament. And Lord, of course, the relevance of this point is that the pronouncement by the courts on the constitutionality of the articles of the Constitution, in my respectful submission, invariably require a consequential parliamentary action. So that's a point that I hope to develop for your lordship, Lord, as we go along. Lord, the bill also sought for a deletion of Article 19(1)(f) and Article 31 and the insertion of Article 300A. Now, about the fate of that bill, what exactly happened to it is at item 12. The Constitution Bill was considered by the Rajya Sabha. During the consideration of the 45th Amendment Bill by the Rajya Sabha on 31st August 1978, the motion for retaining Clause 8 as a part of the bill was put to vote. The motion was not carried by a majority of the total membership of the House and by a majority of not less than 2/3 of the members present and voting. Note, the proposed amendment of 31C in terms of Clause 8A of the Constitution Bill was thus omitted from the bill by the Rajya Sabha. Thereafter, a consequential amendment to 31C was moved under Clause 7A. Now, I'll just read it, Lord. Shri Shanti Bhushan, may I have your permission to move a consequential amendment now that Article 31 has been deleted by the adoption of Clause 6? Reference to Article 31 in Article 31C is inappropriate. Therefore, I'm moving Amendment 103 that the page after line 4, the following new clause be inserted, namely in Article 31C in the Constitution for the words and figures Article 14, 19 and 31, the words and figures Article 14 and 19 shall be substituted. So now that is how, Lord, Article 31 came to be deleted from Lord. I'm sorry, but that is how, Lord, the mention of Article 31 came to be deleted from Article 31C. But Clause 7A was thereafter put to vote. The motion was carried by the majority of total membership of the House and a majority of not less than 2/3 of the members present and voting. Now, Lord, as a result of this, what did Article 31C look like? I put that out in 13.
Yes, Mr. Chandrachud.
Please, Lord. Lord, the result, Lord, what Article 31C now look like, Lord, as a result of this legislative process, Lord, I've set out at item 13 of my list of dates, page 70. Lord, the saving of laws giving effect to certain directive principles, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent or takes away or abridges any of the rights conferred by 14 and 19. So 31 stood. Now, Lord, now we come to Minerva. Lord, if your Lordship will turn to page 18 of my list of dates. Lord, on 9th May 1980, Lord, we have the order in Minerva Mills case. Lord, the Chief Justice, Justice Chandrachud, P.N. Bhagwati, A.C. Gupta, N.L. Undwalia, and P.S. Kailasam. Lord, 5 judges. Inter alia holding, or this is of course the majority view, that Section 4 and Section 55 of the Constitution 42nd Amendment Act to be void on the ground that it destroyed the basic structure of the Constitution. Now, Lord, I've only extracted here, not some part of the order. But Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of Parliament and is void since it damages the basic or the essential features of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19 of the Constitution, if the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 of the Constitution. And as far as 55, just for 55, just for the sake of completeness, Section 55 of the Constitution is beyond the amending power of Parliament and is void since it removes all limitations on the power of Parliament to amend the Constitution and confers power upon it to amend the Constitution so as to damage or destroy its basic or essential features or its basic structure. So what Section 55 was that section that brought about amendments to 368, not giving Parliament plenary powers to amend. Note, Lord, the reasons for the decision were given in the judgment on 31/7/1980. Your Lordship said August. Your Lordship is not entirely wrong, but 31st of July 1980. See Minerva Mills given below. Lord, there is a typo I noticed in one of the other judgments which refers to May. It is actually delivered on 31st July 1980. I think Justice Bhagwati's judgment states the date incorrectly.
Actually, right. 31st July 80 was post the vacation probably.
Yes, yes. The day Abhinav was born.
Now, Lord, Vaman, sorry. So, Lord, then, Lord, I just referred to the judgment and the reasons coming later. But on the very same day, we have the judgment in.
This is something which we'll have to bear in mind, that though Minerva strikes down the entirety of Section 4 of the 42nd Amendment, by virtue of which all or any of the principles in Part 4 is struck down, Vaman Rao, for which the reasons are delivered later, Vaman Rao upholds 31C to the extent to which it was upheld in Keshwanand.
Unamended.
That is the unamended. Section 30, Article 31C.
Because unamended was challenged there.
Right.
Not the amendment was not a
The
subsequent.
amendment of Vaman Rao.
And Vaman Rao is subsequent in time.
No, what was challenged in Vaman Rao was the unamended.
Yes, the original because it came from High Court.
By then, Keshwanand had been delivered.
Yes.
So they say that.
No, interestingly, that's what because if we see Minerva came in July, Vaman Rao came in November, in spite of noting that it has been set aside in Keshavan. After that, a separate finding has been given, independent finding to say that unamended is declared unconstitutional.
Correct. What is the basis of that?
Well, the interesting
Unamended is the challenge.
That has been equated with 31A principle, Manas. To say the 31A, independent of Keshavnath, the independent 31A principle applied. And interestingly, by that time, Minerva was in hand. We had a judgment on that day.
Yes, Mr.
Lord, I am obliged to my learned friend. Lord, then he is undoubtedly correct in that. Lord, that the Vaman Rao rationale for upholding the unamended 31C was on an equivalence with 31A, which is what I will point out. But Lord, the point of relevance, Lord, for the present argument is that this question with regard to the unconstitutionality of a substituted provision was never present before the judges in Vaman Rao's case. For the simple reason that when the hearing stood concluded, the result of Minerva Mills was not. So, Lord, the judgment could really never tackle this issue. But I'll come to the separate point about what is the effect of, Lord, that declaratory statement which is made in Vaman Rao. But this issue which we are dealing with, but precisely this issue was not present in Vaman Rao's case either. Not for this reason, or for this coincidence of time. So, my lord, we then have the, I'll just finish this in a few minutes, my lord, we're coming to the end, my lord. On 9th May 1980, my lord, item 15, my lord, we have the Vaman Rao order. My lord, and here we have Chief Justice Chandrachud, my lord, Justice Bhagwati, Justices Krishna Iyer, Tulsapurkar, and AP Sen. My lord, it's reported in 1983 SCC, 5 judges upholding the validity of unamended Article 31C to the extent to which its constitutionality was upheld in Keshav Nanda Bharati. Article 31C of the Constitution, as it stood prior.
My learned brother Justice Roy is saying something.
No, I'm just going to say that instead of saying Chief Justice Chandrachud, you can say Chief Justice Chandrachud 1.
Lord,
Yeah.
present, I will take your lordship's advice on that. Lord,
We can.
perhaps as the former Chief Justice Chandrachud.
Equally a senior.
Lord, it is a problem which doesn't come to counsel very often, my lord. It is a problem which presents. My lord, so my lord, the judgment in Vaman Rao is delivered. My lord, and the extract is there, my lord. Article 31C of the Constitution, as it stood prior to its amendment by Section 4 of the Constitution, 42nd Amendment Act 1976, is valid to the extent to which its constitutionality was upheld in Keshav Nanda Bharati. Article 31C, as it stood prior to the Constitution Amendment Act, does not damage any of the basic or essential features of the Constitution or its basic structure. The effect of the substitution of the words all or any of the principles laid down in Part 4 for the words principles specified in Clause B or C of Article 39, effected by the 42nd Amendment, was not at all considered. Now, my lord, thereafter we have the judgment in Minerva Mills on 31st July 1980. My lord, the judgment is far too important to try to summarize. My lord, I will take your lordship to the relevant passages, but for your lordship's convenience, my lord, I have tried to summarize it, my lord, by referring to various passages at page 20. Now, my lord, I will not deal with the note here, my lord, because I'll make my submissions on Minerva Mills case, my lord, separately. My lord, I just want to point out to your lordship in conclusion of my list of dates, 2 or 3 more dates. On 13th November 1980, we have the judgment in Vaman Rao. My lord, once again, my lord, it is a matter of great moment to this argument. My lord, I will read from the judgment itself, if your lordships don't mind. And my lord, then we have 2 or 3 other interesting developments. My lord, on item 18, so my lord, once again in 1980, we have 3 very, very important judgments, all dealing with Article 31C. We have the third of those judgments, my lord, which is on 13th November 1980, the order passed in Bhim Singh Ji's case. Now, Bhim Singh Ji's case.
Remember comes Bhim Singh Ji.
Yes, Bhim Singh Ji. Now, my lord, Bhim Singh Ji's case was the case which was referred to by my lady yesterday, my lord, in the context of the urban land sealing challenge. As my lady knows, my lord, in Bhim Singh Ji's case, the result of the majority was to strike down only one section, which was 27(1). But Lord, the effect of Bhim Singh Ji, Lord, is a very neutral effect on this argument. Lord, for reasons that I'll come to when I deal with the judgment individually. Now, Lord, your lordship will only note, Lord, relevant to the facts of this case. Item 19, on 26 February 1986, Chapter 8A of Madar is now introduced. So, Lord, just to contextualize it, Lord, to the facts of our case, Lord, this happens there. And, my Lord, sorry, my, I seem to have omitted to mention to your lordship one relevant date, my lord. Item 16, I'm afraid I failed to read that, my lord. Lord, if your lordship will see the note, Lord, the judgment in Minerva Mills also referred to Sanjeev Coke. Lord, note 2.
Book referred to Minerva Mills.
Yes, Lord.
The reverse.
Yeah, the judgment in Minerva Mills was referred to in Sanjeev Coke.
I'm so sorry. So Sanjeev Coke is the other judgment which also deals with this 31C. My apologies, Lord.
Right.
I misspoke. My sorry. So, Lord, we have Sanjeev Coke, then we have Bhim Singh Ji's case. We then have the insertion, Lord, and then, Lord, if your lordship will just kindly turn to where's the order in percentage? Lord, just there is one more date which I want your lordship to have. I'll just give it to your lordship presently. My lord, the order in Yes, no, that is 1986, the exact date.
86 to
13th
85.
March 1986. 13th March 1986.
Right.
And then we have finally, to conclude this, the order of reference from 3 judges to 5 judges on this issue
That we have seen.
on 1st May 1996. So Lord, that is how the issue now arises before your Lordship.
Right.
But may I now show your Lordship, Lord, the Minerva Mills case.
Yes.
And then I will like to show your Lordship Vaman Rao, Lord, before we move further. Lord, so if your Lordship doesn't mind, Lord, Minerva Mills. Lord, your Lordship will find that at page 2050 of the precedence compilation which your Lordships have. Lord, we are principally concerned here, Lord, with the majority view. But, my Lord, Justice Bhagwati actually, Lord, does something quite unusual. My Lord, Minerva Mills, he also deals with Vaman Rao. So, my Lord, may I refer your Lordship first in Minerva Mills, my Lord, straight away, my Lord, to the question for consideration. And that your Lordship will find at page 639. Internal 639, which is 2064. Your Lordships have that, my Lord.
Sandhya,
Yes, my Lord. So, my Lord, in the first paragraph, my Lord, the question is summarized, my Lord. My Lord, in Keshavananda Bharati, this court held by a majority that though by Article 368 Parliament is given the power to amend the Constitution, that power cannot be exercised so as to damage the basic features of the Constitution or as to destroy its basic features. The question for consideration in this group of petitions under Article 32 is whether Section 4 and 55 transgress the limitation on the amending power. Then, if your Lordship will kindly notice in paragraph 5, what a curious feature of this case was that the statute in question was actually a pre-amendment statute, as your Lordship will see. By these petitions, the petitioners challenged the constitutional validity of certain provisions of the Sikh Textile Undertaking Nationalization Act and the order dated October 19, 1971. We are not concerned with the merits of the challenge at that stage. And then, my Lord, the way the matter proceeded was on a basis of a concession, which I want to bring immediately to your Lordship's attention. My Lord, there is, if I may say so, my Lord, you will find in paragraph 7 to paragraph 12, my Lord, a masterful and clear exposition of the law in Keshavananda Bharati. A judgment which it has been perennially difficult to exactly distill the meaning, but my Lord, there is a masterful summary which I found very useful in these paragraphs. And then if your Lordship goes straight from there, Lord, please go to paragraph 24.
At 23 at page
24, Lord, it is at page 2069. And the point I want to make here, my Lord, is that the entire case proceeded on a concession. As your Lordship will notice, Lord, I won't paraphrase it, but I'll just read it. The next question which we have to consider is whether the amendment made by Section 4 to 42nd Amendment of the 42nd Amendment Act to Article 31C of the Constitution is valid. Mr. Palkiwala did not challenge the validity of the unamended Article 31C. So, Lord, it's very clearly stated
But they also say, and indeed that could not be done. So they add their own reason, and they add the reason for it. The unamended 31C forms a subject matter of a separate proceeding, and we have indicated therein that it is constitutionally valid to the extent to which it was upheld in Keshwan and Bharati. So the unamended 31C was valid for the reason that it was upheld in Keshwan itself.
It was a subject matter in Raman Rao.
That's right.
So Justice Bhagwati notes in detail on page 2088.
That's okay.
Very extensively dealt in minority of Justice Bhagwati.
No, my learned friend is right again. Lord Justice Bhagwati is.
Mr. Chandrachud tell us this, that para 1 of Minerva says that what was challenged in Minerva was the constitutional validity of section 4 of the 42nd Amendment.
That's right.
Now, section 4 of the 42nd Amendment comprehended two features. It actually comprehended one feature. Let me begin by saying that. It comprised the entirety of the provisions of directive principles which are now brought in by way of the amendment. So that would include 39B and C and the other principles in part 4 of the Constitution apart from 39B and C. Now the validity with 39B and C was already dealt with in Keshwan and Bharati.
Your Lordship is right.
Right. Therefore, though the entirety of section 4 was in issue, I guess the problem which the Minerva bench felt was that they couldn't bifurcate the two, because what Parliament had done had to bring in one composite amendment. So they couldn't bifurcate between the 39B and C part and the other parts of the directive principles.
Lord, I would agree with your Lordship respectfully, my Lord. Because, Lord, as your Lordship rightly pointed out, Lord.
Bring it down.
Para 24.
Para 24.
Page 20.
Oh, that's what he was reading actually.
I'm not the
You are reading para 24. That's why, that struck me that Mr. Palkhiwala also doesn't challenge the validity of the unamended 31C. Because it was upheld in Keshwanan. And therefore, though there's a concession by Mr. Palkhiwala, the court says, and indeed that could not be done. They have endorsed it. As we do so many times in our orders, that learned counsel did not, or argued, and correctly so, so that we are lending our own authority to the submission of counsel.
Yes, Lord, your Lordship is right, and it does add a slight complication to the matter. But I believe what
I opposed to Vaman Rao because Vaman Rao was pending at that time.
Lord, so the curious, in one sense, it comes down to Keshav Nand.
Reasons had come in July. The operative order in Vaman Rao had been pronounced. May. So they knew that they had upheld the constitutional validity of the unamended 31C in Vaman Rao. The reasons were to follow later in November.
But I would add to that a little bit, Lord. In fact, if your Lordship sees the order in Vaman Rao, it's not exactly in line with the reasoning in Vaman Rao. If your Lordship just comes back, the reason why they said this.
It's a conundrum, because while Minerva sets aside the entirety of Section 4, Section 4 comprises a smaller subset which has been upheld in Keshwanan. The bench in Minerva did not have the ability to say that it was severable, because the severability would not arise, because it was one amendment, it was one substitution, it was composite. Otherwise, they would have severed it. They would have said what has been upheld in Keshwanan, we can't strike it down, but they didn't have that choice here because it was one composite amendment. Otherwise, they could have applied the test of severability. But when you apply the test of severability, something which is valid has to survive. Here, they could not apply the test of severability because it was composite. So, in a sense, that was intellectually the problem which the bench was facing. I mean, they don't articulate it in that way, but obviously it's clear. That was therefore, they strike down the entirety of Section 4.
Lord, may I add to, Lord, I am complete respectful agreement with everything that your Lordship said. And Lord, I'm glad that your Lordship said it rather than I saying it. But Lord, may I add one or two things that I could say about it, Lord. If your Lordship were to see the order in Vaman Rao, it actually says this. The reason why they actually repeated this in Minerva Mills was that the order in Vaman Rao, which was available by the time that the judgment came in Minerva Mills, for which your Lordship will find conveniently at para 15 of my list of dates, page 19. But it says this, but I'll just read your Lordship again. 31C as it stood prior to its amendment is valid to the extent to which its constitutionality was upheld in Keshav Nanda Bharati. So the reason why, Lord, they used this very language in Minerva Mills was this was the order in Vaman Rao. But what this meant was actually explained by the judgment in Vaman Rao. But I'll just come to the judgment in Vaman Rao in a minute. Lord Vaman Rao, Lord, decided on independent reasoning, not on the doctrine of precedent and Keshav Nanda Bharati, but arrived at the same conclusion. So, Lord, that is how this statement comes to be a part, and that is the correct meaning to be ascribed to the latter part of this concessionary statement.
But then if Vaman Rao independently applies, uphold the unamended 31C,
Yes, Lord.
right? Does
That
it
is the
hold it
application.
only for the period prior to the 42nd Amendment, or does it then, is it capable of the inference that, well, that the unamended 31C survives the striking down of Section 4 in Minerva?
So, Lord, your Lordship has once again, Lord, rightly identified the complication. Lord, as soon as we deal with Minerva, my Lord, permit me to go to Vaman Rao. But would your Lordship mind if we just finish with Minerva once?
Well, we saw para 24. Let's go ahead. You can go in
So,
here.
24 is a para, my Lord, of considerable importance.
Para 25 also.
25.
Yes, 25 also. But of course, not the whole judgment, my Lord, is
Zal, you can read para 24.
24 again, please. But I'll read it slowly. The next question, which we have to consider, is whether the amendment made by Section 4 of the 42nd Amendment to Article 31C of the Constitution is valid. Mr. Palkiwala did not challenge the validity of the unamended Article 31C and indeed could not be done. Now, why could it not be done? The unamended Article 31C forms the subject matter of a separate proceeding, and we have indicated therein that it is constitutionally valid to the extent to which it was upheld in Keshav Nanda Bharati, and the asterisk
Not a
takes us.
concession.
It's not a
It
concession.
is not a concession at all. It is because there is already a decision of Supreme Court
Yes.
which has upheld the validity of
In Keshavanand and independently in Vaman Rao.
It's an authoritative pronouncement.
It is an.
Lord, I accept what your Lordship say. Lord, that yes, it was not. Mr. Palkiwala made the concession, but the judges said that on the basis of the concession and on this basis, in fact, the concession was unnecessary because Vaman Rao had already decided this one.
Will it be also right to say that it was a concession by Mr. Palkiwala? Mr. Palkiwala, he said that he did not challenge it. That doesn't mean that, you can put it as if there was a concession made.
he stated the correct position of law. This is what has happened.
So, my Lord, yes, your Lordships may well be right, Lord. That also works for my argument, Lord. I don't need to dispute that. Yes, Lord, it could well be that what Mr. Palkiwala said, that in view of the order now which is passed in Vaman Rao, I don't need to challenge it, albeit, my Lord, I may respectfully differ from your Lordship for this reason. Lord, consider the timeline. Lord, at the time when the matters were being heard together, the order in Vaman Rao was not out. During the course of the hearing, the order was not out. Lord, so Mr. Palkiwala, my Lord, would not have been able to, my Lord, know that in Vaman Rao this would have been the case. But by the time that the judgment is delivered in Minerva Mills, the order in Vaman Rao is out. So the judges have the advantage of that order. So, my Lord, the way that I read this, my Lord, given this context.
It's almost 4 o'clock, but the only point which we'll have to consider is this. You can reflect on it.
Please.
The net result of Vaman Rao and Minerva Mills is this. Vaman Rao upholds the unamended provisions of Article 31C on reasoning independent from that in Keshwanand.
Well,
The amended provisions of section Article 31C as amended by the 42nd Amendment are struck down in Minerva Mills. Now, does Vaman Rao really mean that the unamended 31C is upheld only prior to the date of the insertion of the substituted provision by the 42nd Amendment? Or does the unamended 31C continue to operate both before and after Minerva?
Your Lordship has put the problem perfectly, actually. Your Lordship does know, I think that my answer would be the first. But, my Lord, I'll deal with it, my Lord, at some length tomorrow.
Is that clear? Because then what was the purpose of Vaman Rao? Because
Yes.
see, the unamended provision of 31C had already been upheld in Keshwanand. Right?
Right.
Now, Vaman Rao they had to deal with, then why would they write a judgment in Vaman Rao?
Yeah, my Lord, I will show your Lordship. Yes, my Lord. But let me not say anything, my Lord.
Benefit of Minerva. They mentioned.
Lord, I will press your Lordship on this tomorrow.
Because see, Vaman Rao, conscious of the fact that they have struck down section 4 of the 42nd Amendment, yet proceeds to hold that the unamended 31C is valid.
That's correct.
Is that not therefore susceptible of the inference that they treated 31C to be continuing in operation, though in its unamended form, post the decision in Minerva?
But I will reflect on that.
Just reflect on it, Mr. Darshana. We'll continue tomorrow morning.
Deeply obliged.
Let's see what was the nature of the challenge in Minerva. You've shown us para 1. With the nature of the challenge in Vaman Rao, we'll also reflect on it in the evening and in the night today and look at it.
Sir, deeply obliged, sir.
Mr. Andarjan, are you headed back to Delhi tomorrow or no?
Yes, I will be, my Lord.
All right.